Judge Cooper rules on a dismissal, and AG Moody is back in the news.
The ACC lawsuits are always in the news, so we're back on the big mountain to break it down for you.
Hey, welcome back to the mountain. I am JY. This is my good friend Steve. Steve, we had the conclusion to the Leon County hearing here on Monday. I know you and I both were able to listen to a good portion of it. Fortunately, it wasn't as long as the first hearing was, and you could tell the judge wanted to keep things moving along here in this one, I think. So I'm sure, as everyone knows by now, Judge Cooper dismissed the FSU lawsuit with a leave to amend. Basically, that means right now FSU has 7 business days. They talked back and forth in terms of how long they needed. FSU said 7 days. So 7 business days to refile their brief, giving adequate justification to Florida having jurisdiction in this case. Cooper was pretty clear he didn't want to have this marathon hearing like he had on day one. He wanted to kind of stay on point. During the hearing, Cooper had a lot of back and forth, mainly with FSU. I mean, FSU was talking with Cooper quite a bit in this hearing. ACC, very to the point, said what they needed to and sat back down. Yep. This was a lot of FSU speaking on this second day. And he actually needed to remind the attorneys there not to get into the merits here, but again, to stay on point and for the purpose of the hearing, that being the dismissal. And then also they were going to get to the staying of discovery, but they didn't even get to that. And we'll talk about that in a minute.
And I didn't count, but I feel like he had to remind the Florida State attorney 4 or 5 times. I don't want this to be a marathon. Yes. Stay on topic. We're not going to get in. I kept hearing, we're not going to get into that now. We're not going to get into that now. Definitely, it seemed like he was getting irritated with the pace of things.
It felt that way. The pace and just and the FSU attorney was saying, well, I'm saying this in order for me to get to that. And I agree. He felt like he was just kind of tired of that. Let's get to it. He was also trying to help them move forward too, not just let's get to it, but is this what you mean type of thing. Yep. And he even took what I think lunch early. I mean, they broke at like 11:30, which is fairly early for a court, to allow them kind of time, I think, to better get back together, that to articulate what we're trying to articulate. But even then, when they came back, he would ask several different questions of the attorneys. And he would say, was that in your filing? Is that on the record? And the FSU attorney blatantly just had to say no. I mean, he didn't have a response other than no, because it wasn't in their original pleadings, their original filings. And that happened several times where the attorney just had to kind of say no to it. Yep. At that point, I could see where this was going. The judge wanted more, and it wasn't there. And that really became the main focus of the ACC. As they stated, the FSU complaint was insufficient to allege the pleadings of personal jurisdiction. And that's where Judge Cooper had a lot of issues with this whole jurisdiction in terms of, and I don't think he doesn't think it's going to move forward. It was almost like, yeah, I know what you're trying to say, but you didn't say it correctly in your filings and in the record, and that's a problem for you guys, basically. And I'm going to give him a lot of credit here. He had to dismiss the case for now until proper jurisdiction is determined and given. And he actually stated that if it wasn't done now, he knew exactly what the ACC attorneys would do on an appeal, and he was kind of like, yeah, I could do it now, but we know that it's going to get appealed, and I don't have a great leg to stand on, even though, yes, there's probably jurisdiction here. You screwed up in your filing. Exactly.
You got to fix it in order to make this make this appeal proof when I do rule that, yes, there is jurisdiction.
Exactly. So he's giving them a do-over, basically. It's kind of a do-over on their filing. And while some, basically, it's just a slight pause right now. It's really not a big thing, other than I'm going to get into why I think it is a bigger thing. The dismissal isn't a big thing. I think what is potentially a big thing, and it gets back to what we talked about with Doug Rohan last week in terms of the timeline. Yep. So I'll get to that here in a minute. While this little bump in the road can be remedied, it does delay this Leon County case and puts the NC case back in the lead. I think pretty dramatically. I'm going to go over, after we finish this and go over the AG thing, I want to talk a little bit about timelines of these hearings, at least what we know right now. We all knew there was a race to the courthouse. That's been clearly determined. FSU said that in every filing they had. There's a race to the courthouse. The battle now is really a race to a ruling. I know a lot of people say, hey, we're going to have a settlement. I get that. But at this point, we don't have a settlement. So we're going down the path of we're going to have a hearing, we're going to have a ruling, and if there's a settlement, which a lot of us think, great, but we're not there right now. So let's talk about what we know.
Both sides would like to be ahead on the timeline in their preferred venue, for sure.
So let's remember what Doug said about these dueling cases, and he said it on our episode. I'll link it up above. If you didn't see that episode, go back and look. Again, this isn't coming from the mouth of JY. This is coming from the mouth of Doug Rohan. And he, as he puts it, this is when you get into constitutional questions about the full faith and credit clause of the U.S. Constitution. The decision of one state court must be recognized and ratified by other states, according to Doug. This is why the race between these jurisdictions is very important right now, and why this delay really favors the ACC. It is not because, again, there's this short-term dismissal. Yeah, I mean, technically, yes, it's just refiling so that they can do it correctly, or at least have state what they need to state correctly. But it's potentially putting the NC case further ahead of this Florida case in what I'm going to call now a race to a ruling. That's what they're going to try to get at through the appeals and through all of this mumbo jumbo they're going to try to go through. So that, that's kind of where I'm at here with this, Steve. Other items real quick that came out of the hearing was that the venue was conceded by the ACC. That happened early on. So then obviously it was conceded, so he denied that, and that dismissal premise. The rightness argument was also denied. And then at the end, when they got to staying of discovery, he basically is like, well, if I'm dismissing this, there's no need for me to rule on staying discovery, because at this point it's dismissed with a leave of providing an amendment, so there's really nothing to stay in terms of discovery. So he kind of just let that open for the time being, and he'll hear that again once they revise their or amend, have a second amendment to their filing. So what were your thoughts on the hearing?
Yeah, same thing as you. I think that the judge, I think he overall did a good job. I think he showed some frustration with the FSU attorneys. Okay, you're saying this, well, why didn't you put that in your amendment?
Yeah.
Kind of helping them out, like you said. The ACC attorney was pretty, which an FSU alum, which I found was interesting. The ACC attorney, she was pretty simple and clear, just saying that there wasn't enough. It was not, the filing was not adequate,
right.
And she didn't really need to go farther than that.
Yep.
Definitely, it's a. We know that this is putting some kind of a delay in the Florida case. Mm-hmm. The judge originally had said. He said something about we're going to break the glass in 90 days.
Right.
And then basically once he did this ruling with the dismissal with an amendment, mm-hmm. He said, well, that's probably going to add, I think he said 20 days. I think he said, we're going to say 90 plus another 20
right.
to give you time to submit the amended filing, and then give the ACC a chance to read it and, come back with any arguments that they have. So, right. It looks like this is adding, roughly, from what the judge was saying, probably 20 extra days that they didn't need. Now, I think every legal expert has been pretty clear that they don't believe this will go to rulings, but you never know.
Right.
So, if this is a race trying to pull ahead on time, they lost themselves some time here. I mean,
right.
There's just no way around that.
So let's talk real quick about the timelines. So in Leon County, the FSU now has until May 1st. Now they can file before, or they can get this in before that, but they have until May 1st to get this second amended complaint filed with the courts. And the ACC then has 20 days to respond to that. I would assume they will take 19 or 20 days. Who knows? But I would assume they're going to take most of those days. So that gets you kind of towards the end of May, certainly the second half of May, and then till they actually come back and schedule a hearing and get back in the courtroom and all that kind of stuff. I mean, you could be talking July.
I think he mentioned July as when arguments in actual trial would go on. I think he definitely mentioned July. Now, one thing I will say, because he talks really openly about his scheduling. You know,
right,
it's just an open meeting with him. Whereas down in Judge Bledsoe kind of keeps things to the vest, and he just he tells you what he wants you to know when he wants you to know it, kind of thing.
Right.
So we don't know what that scheduling is going to look like in North Carolina. I will say, I noticed today, I was kind of just reading some, I went back to try and catch up with Doug Rowan and some other folks, just kind of on their feedback since they had a couple days to digest the hearing. And Doug suggested, and a couple other people suggested the same, that yes, they're losing time. You know, there's no way around that. They are losing time, and time is precious. However, the chance to go back and amend the filing, not only do they get to amend this particular part that the judge had an issue with for this ruling, they also get to now look at Clemson's filing and pick some stuff that was good from there and change some other things based on some arguments that Florida State has made. So Doug seemed to suggest, and I'd love to have him on again. I know we've been communicating with him on X and Twitter. Doug seemed to suggest that it was kind of a trade-off. You know, good and bad. You lose some time, but the opportunity to go and redo this filing, he called it, and I guess it's a common law school term, is another bite at the apple, basically.
You're right. Okay.
Which is very interesting. We'll see how that works out.
Well, if we're trying to get to a ruling, I'd rather be ahead right now in terms of timeline. Just me. I hear what you're saying, and Doug what he's saying, but I'd much rather be on the court that's pushing the pace, trying to get this done. That doesn't mean something can't happen in Mecklenburg. It's going to slow it down dramatically.
Well, yes, I agree. If you're worried about the time race, I mean, you definitely want that time. You don't want any setbacks in time. Now, Doug is still in that camp, and I think a lot of people are that it's not going to get. We're never going to get to a ruling. So for him, that's kind of here nor there. I mean, he definitely admitted that there was. It is a loss. It's a loss of time. But he didn't seem too worried about it, which I just thought was interesting. We'll see how that plays out.
Well, if we want to just agree that we're going to have a settlement, we'll just stop doing these.
Yeah.
Because these don't mean anything until we get a settlement. Now, and I'm saying that tongue in cheek. I think these are interesting. I think they all inch our way to a settlement when you hear things and certain sides. And you've said this many a times, and I say that in complete jest. But when somebody gets a leg up, and you brought up the PAC case before, and settlement before, and how the dominoes started to fall for one side. That's when you can see, kind of where that settlement starts to happen. And I think that's what's one of the important parts of following this, is that if you see one of these sides starting to get that leg up, starting to, get more of their case heard in favor of them, and get opinions of judges and whatnot in favors of them, that's when a settlement's going to play. Again, right now, this, to me, we said this from the beginning. This is kind of a horse race. Maybe one pull ahead a little bit, and then somebody will pull back. I'm still 50-50 on this. I wasn't going to try to get into that right now, but I'll tell you, I still think it's anybody's game.
I think so for sure, and that's why we don't have a settlement yet.
Right.
Because if it was clear that one side was getting their butt kicked,
sure,
with that, like we saw in the PAC, and Judge Cooper is still on his mediation, and he said during the hearing, he said, I know it may not work. It doesn't always work, but I want you to go through this process. And we don't know how that's going to affect the timeline in Florida either. Judge Bledsoe hasn't. I don't think he's really mentioned that. I know, our commenters have brought this up many, many times, that in Florida it's required for the judge to at least order mediation. Yeah. Now, what he said is he can't force them to come to a settlement, but he can force them to get in a room and go into mediation. So we'll see how that affects the timeline as well.
Well, and I think if you read the tea leaves, you've seen a little bit of that in the hearings from where things started. Yep. We've talked about that too. And let me get back to Mecklenburg real quick, and then we're going to jump on the AG Moody letter, because we've got to talk about that as well. But in Mecklenburg County right now, we know there's going to be a hearing on May 2nd, so just next week. And this is for the hearing on discovery while the appeals process takes place, whether or not that's going to happen simultaneously, quite frankly.
Right.
So that's going to be interesting. Again, trying to keep that timeline moving in North Carolina. That's huge. If Judge Bledsoe is going to allow for discovery to keep the case moving forward, even if it's being looked at upon appeal, that's a big timeline bump for them in Mecklenburg. We haven't heard anything about the appeal, the Supreme Court, or anything like that. I haven't seen any dates on that. But let's stay focused at least on Judge Bledsoe.
Yeah, and if I remember correctly, it's kind of switched there. In North Carolina, Florida State's trying to stay. They're asking for a stay for discovery. They're trying to slow it down.
They're trying to slow it down.
And I think we'll see more and more of that, each side putting these delay tactics in the other venue that's not their preferred venue, which goes back to the argument, and what I asked Doug on our show, the forum shopping. Yeah. Doesn't everybody forum shop? Right. I mean, it's clear that the ACC wants this in North Carolina. They feel like they have the advantage there. And it's also equally clear that Florida State wants this case to be held Leon County, Florida, because they feel like they have the advantage in the state and in that venue. Both of them, they have their preferred venues, and they're trying to delay the other side as much as they can in the place that's not their preferred venue.
Yes, yeah, for sure. Before we get into AG Moody, I just want to say we are going to have an episode on Clemson come out. That's been really hush-hush. We had a few commenters ask, what's going on with Clemson? I dove into the actual court filings, both in South Carolina and in North Carolina. There are some filings there. It's not getting any play, so we're going to get that episode out tomorrow. And I would just say to the FSU fans that, be watching that case too, because, these are definitely going to be piggybacking a little bit. I'm not trying to get our views up on that.
Yeah.
I am just saying it's really important to watch both of these. If you're a Clemson fan or an FSU fan, you really should be paying attention to both sides of this. And it was interesting to see what's in that. I think I say it was interesting like 1,000 times in all of our episodes.
It's very interesting.
But yes, thank you. So anyway, we'll get that one out tomorrow. So let's get to the Moody letter. You ready for that?
Yep.
And this is sovereign immunity hardcore.
Yep.
And I'm going to bring up Doug's comments again on sovereign immunity after we kind of lay out what this letter said. Because he hit on this a little bit. Not a little bit. We asked him specifically about this, and he gave us a specific answer just, about 4 days before this letter was made public. So on April 17th, 2024, the Attorney General for Florida, Ashley Moody, sent a letter to the AGs in California, Georgia, Kentucky, South Carolina, Virginia, and Pennsylvania. This comes after almost 3 months of silence on the office, from that office in Florida. And I reached out. Our viewers that see every episode know that I've been reaching out to them, asking if that public record request was still open. It took them a while to get back to me, but they said, yes, it is still open, but it's been like super silent until this letter kind of breaks. And I think she's kind of getting the lay or a feel for the land. Who else is out there that it has interest with me? At least that's my read on this, but I'll get to my opinions in a minute. The main point of the letter, at least my reading of it, was to direct these other attorney generals in these other states, direct their attention to the FSU and ACC lawsuit in North Carolina, where the trial court, Mr. Judge Bledsoe, or Honorable Judge Bledsoe, concluded that FSU waived its sovereign immunity and can be sued in the state of North Carolina. She points out that the potential impact of the lawsuit could subject FSU to a loss of more than $500 million, and that any waiver of sovereign immunity should require an especially clear waiver in her letter. She continues to say the public institutions in these other AG states have voted to approve a filing against FSU, and that she doubts any of these attorney generals were included in that decision. She speculates that for all she knows, the ACC may not have explained the future implications of their act and possible ramifications. She says that the position of waiving sovereign immunity that is being advanced by the ACC is detrimental to all of these states. She says that they may not have the protection they think they have under the U.S. Constitution, their state constitutions, and other state statutes. Lastly, she asked them to engage with their universities on this if they see the risks the same as she does. She states that Florida is considering taking action in the appeal in North Carolina. So I have some opinions here on this. Let me shoot it to you, and then I want to talk real quick about what Doug kind of said on sovereign immunity, and I'll give my thoughts. So, you ready to go to Doug, or do you want to chime in?
Yeah, why don't we go straight to Doug? I'll save my thoughts.
So, again, going back to what he said with us last week on sovereign immunity, if this is a proper contract, and he was clear, the contract has to be proper. It has to be properly authorized, consideration, all that. So we have to assume that the contract is proper here for right now. Then both an explicit and an implicit waiver is allowed. And you actually had a question about that with him, and he was very clear on what the statute says one thing, but the Supreme Court down there said another thing. So both explicit and implicit waivers of sovereign immunity are allowed. Doug frankly called BS on the FSU argument that FSU can be sued in any court and not in any court in Florida. He concluded that this does not provide any protection for the case in North Carolina. Now, I know opinions change, facts can change, but we said, even before we had Doug on, I was very clear that it says any court, meaning any court. It doesn't say any court in Florida. And Doug actually kind of agreed or concurred with my view on that, which I enjoyed to hear, that he agreed with what I was saying. Maybe I agree with what he's saying is probably the correct way to say that. So at least for now, his opinion, I think, would be that the sovereign immunity piece is not a huge risk here. But we'll see what happens with AG Moody, because, I think she's, again, like I said in the beginning, she's putting her feelers out here to see if maybe there's some allies on the other side, if you will. So what are your thoughts here, Steve?
Yeah, well, again, from the very beginning, I always anticipated that some political entity in the state of Florida was going to get involved at some point. They just can't help themselves. So the Attorney General, she's a lawyer. She is the lawyer for the state of Florida, but or the top cop, as some people will call them. But at the end of the day, she's a politician. So, it does not surprise me that she's continued to get involved in this. It really surprises me that her and the governor have not already gotten involved in some way, because I've been saying I thought that would come, for a while. I think if this is limited to just her, and it's somewhat important, it's an interesting aspect to the case, especially if she files in the appeal, makes a filing, joins that appeal in the state of North Carolina, and so if it's just her, if she's the only one and she joins the appeal, I think it's somewhat interesting. It may change the dynamics of the case slightly. Where the massive opportunity is, and we'll see what comes of it, is if she can get the attorneys general from multiple different states. And I would say not just South Carolina, because if she gets South Carolina, then that's just the two states. But if she could get another attorney general beyond the state of South Carolina, I think that would be a huge shift in the dynamic of the case. We'll see where it goes from there. And then going back to, I don't think here's the thing is with this case, there is a certain viewpoint that it's a simple contract, and that's it. Okay, whatever's in the contract, this is the contract. This is contract law. It's easy. I still think that sovereign immunity is going to continue to rear its head throughout this entire case. And when I was reading, I think it was Matt Baker's article in the Tampa Bay paper about the case, he referenced some older ones, and I started to do a little bit of research today, but there wasn't a lot of time between work and us recording. And so I found some different things that were interesting. He basically cited previous times where states had gotten involved in these suits and cited sovereign immunity concerns. One of them was Maryland. The state of Maryland sued the ACC because of that. They thought the penalty was too high, and that penalty actually ended up getting reduced, which I thought was interesting. And then one that was really interesting that I had never heard of before, I don't remember hearing about this, was, and there was a couple other states, I think Connecticut and a couple other states, maybe Virginia, had joined that other suit. But one that he mentioned was the state of Florida. Charlie Crist, I don't know if that's a name.
Sounds familiar.
I think he was the attorney general and then the governor at one point. So when Charlie Crist was the attorney general, he sued the Big East, when Miami was trying to leave the Big East and go to the ACC, which Miami is a private school.
Yeah.
But he argued in that suit that the state of Florida, because they played against Florida State, they played against Florida, they played games in the state of Florida, that the state of Florida had basically a stake in that. I don't know if he went full in depth with sovereign immunity because they're a not a public school, they're a private school.
Right.
So I want to go back and look at that. So anyways, I just thought it was interesting that the previous cases, and we'll see if those have any effects on this, if they use that as precedent. I think all of those cases ended up going to settlement, so that's that's just how these go. It's kind of point, counterpoint, shot, counter shot, and then okay, let's settle. So I don't know, how they'll come to play, but it's just interesting. And I think, again, if this stays just Moody, it's somewhat interesting. It could affect the case in some way, but where this could get very interesting is if she can get other states' attorneys general to sign on with her, and then we'll see where it can go. My last point on Doug, and why I had done a follow-up question for him, was that implicit and explicit waiver.
Right.
I think there's some room, and as Doug admitted, you can have law, you can have case law, and you'll have people that have different legal opinions on it.
For sure.
I think there's some room between his opinion that he stated, and Judge Cooper, what he talked about, explicit waiver. And I think Moody's kind of getting into that about the explicit waiver. So that will be very interesting to see how that plays out. If she joins this appeal in North Carolina, and then also if she doesn't get what she wants in North Carolina, does she try and take this to another venue, back to Florida? I asked Doug on Twitter if he thought that this could open an avenue for federal court. She cites some 11th Amendment arguments, which again, I tried to do a little research on that, and it's like it's another can of worms. You just get deeper and deeper. So anyways, if she can get some other states involved, I think it opens Pandora's box to a lot of other things that could make this case expand dramatically. But we'll see.
Well, I would say first, I'll work backwards a little bit. The federal piece, I've seen many people saying, at least right now, it's very unlikely to go federal unless some sort of a federal issue arises out of another case or these cases or something. Again, I don't know the laws and how that exactly works, but I've seen many people opine that having this go federal right now, where we at and what we know with these hearings, is very unlikely. I do want to go back to your sovereign immunity piece because I know you had mentioned to me, you listened to the first hearing, and you were texting me, and I know you were telling me that Judge Cooper was really banging the sovereign immunity drum about this explicit, implicit.
Yeah.
And who knows what that means? We heard that in Mecklenburg, where Bledsoe was kind of asking questions, and you kind of thought, well, maybe he's this way, and he was completely the other way. So you don't know really when they're asking that or trying to push things. You don't know why they're doing that. But I do know that you were really interested, that he seemed to be very focused on this, being Judge Cooper, very focused on the sovereign immunity piece in Florida.
And he, with that one, he didn't ask a question. He stated to the attorneys, "It's my understanding that in the state of Florida, sovereign immunity must be explicit."
Okay.
Which was interesting.
So I have two quick thoughts, and then we'll wrap this one up. My first thought is, I have one that's superficial, easy, probably the correct thought. I have one that's way deeper.
Okay.
And I texted you the second one, so maybe we won't wrap it up real quick. But my first thought is, she's been quiet for about 4 months. Mm-hmm. You haven't heard anything. We've been wondering, and we've got no skin in the game.
Yep.
What the heck is going on with the state of Florida? You've mentioned DeSantis. You've mentioned Moody. You've mentioned, when are they going to get involved? What? Not what. You're really, when are they going to get involved?
Yep.
That's what you're asking.
Yep.
And they have been silent. I am sure she's getting pressure from whomever, the constituents, from other people within government, from DeSantis, who knows from who, to do something. And this is doing something without really doing anything. Like, this letter hasn't done anything. To me, she's testing the waters, considering taking action. It's very safe. It's also showing publicly that I'm willing to maybe get involved. Yep. Hey, hint, hint, nudge, nudge. Who knows? But she's got to be getting pressure to throw her name back in this ring a little bit, since her original public record was request. It was like January 3rd or something like that. I mean, we're literally almost 4 months ago that she brought this up. On a larger scale, Steve, if she does proceed, I'm gonna go. So the first one, I think it's a much ado about nothing for now. But I do agree with you. If she can get another state or two involved, not South Carolina, but another one, maybe there's hay to be made, and very safe way to try and do that. So I agree with you on that. But I'm going to take it a step further. If she does end up proceeding, I feel like this could be somewhat a dangerous game in which any and all grant of rights or copyright agreements are deemed unallowable in the state of Florida. I mean, if that's the degree that she's looking to take this here, and if this is going to somehow set a precedent for universities, and not just universities, for public entities in the state of Florida, that could be a dangerous game. And I'm not saying that's what she's going to do. And I am taking a huge jump that, she's going to get involved and she's going to push this, but she could literally rewrite the history books here in terms of what's allowable in not just the state of Florida. Now, she's only cares about the state of Florida, but what the grant of rights actually mean, what the copyright laws actually mean. I mean, multi-year agreements for any of this type of stuff with FSU could be completely out the door because they can't do it, or any public entity. So yeah, I jumped way down a rabbit hole there, but I kind of look at where the end game could end up, assuming it gets there, which it won't, but assuming that it does. It's a little dangerous, I think.
I want to talk more about that specific point.
Okay.
I brought this up to you, I think, a few times before. Well before we heard from Moody while she was sitting on the sidelines.
Yeah.
There's been a lot of speculation for months now, basically that if Florida State can get rid of this grant of rights, that at least partly using the argument because they are a public institution, a public entity.
Yeah.
If they use that in some way and they're able to blow up this grant of rights, I've seen some speculation that this may mean that no public university anywhere can do a grant of rights. Mm-hmm. Now, could that be good? Could that be bad? Now, and here's the thing: I've always been very curious, a long time before any of this came about, as to how a public entity, a public institution, can engage in something that's secret. I've always had some suspicions about this, so maybe I'm just suspicious about this in general. But I've seen a lot of other speculation that this case in general, whether she gets involved or not, may blow up the entire concept of public universities giving their rights to another entity for them to go and negotiate. Now, what I've seen is that the solution to that would be, let's say Florida State joins the Big Ten, okay? Or let's say Clemson joins the SEC. Right now, the SEC has a grant of rights with their different grant of rights, but they have a grant of rights that they use to negotiate with ESPN. So the proposed solution or the proposed end game or the proposed result of that might be that instead of these conferences, instead of the teams, especially the public schools, giving the conference their rights and their ability, the conference would still be able to negotiate, but basically each individual school would then have to ratify that contract in accordance with the laws in their states for public disclosure and public records, which could be a huge game change because there is value. I mean, ESPN and Disney, they've been very clear that they have value to having a secret agreement.
Yes.
They don't want other people to know their agreement.
Right.
So if the end game of this is that public universities in Florida or maybe everywhere can't engage in these types of grant of rights anymore, that could lower the potential value.
Yes.
It could. So that's something definitely to think about. I don't really think that it has, and I was following, I think David McKenzie, I was following some of the things, and so he talks a lot about contracts between private parties.
Right.
Well, here's the thing: these are not necessary. If the grant of rights is blown up because of the fact that Florida State is a public university and some kind of sovereign immunity or public stake, this isn't just a simple matter of. I don't think it blows up all copyright law because private parties can still have contracts with each other. Private parties can still follow for copyrights. To me, this would just affect public institutions and public universities.
Yes, and I should have clarified that. That's kind of I was trying to say just public institutions.
Yeah.
And you know, we've talked that the grant of rights is unbreakable.
Yeah.
We have, and a lot of people say it's unbreakable. It may go from unbreakable to a nuclear bomb blows it up and it's no longer in existence in one decision.
Well, and in that article, we talked about the unbreakable grant of rights. I think we used maybe a Dennis Dodd article. We talked about that episode. We both kind of said it looks to be unbreakable. They create it, but nobody has challenged that yet. Is it because no one has challenged it because it's not unbreakable, or because it's unbreakable, or is it unbreakable because no one has challenged it yet?
Exactly. Yep. Well, both are true, I would think, right? Or potentially. So, hey, one other thing I want to mention: live episodes we have on Wednesdays. I know this is coming out on a Thursday, but the last live episode we got into a little bit of the speculation that Greg Flugar?
Yeah, I think Flug. Everyone just called him Flug.
Talked about with the whole media rights agreement with Texas and the SEC, speculating what the words are and if this, if that. A lot of ifs.
Yeah.
But we talked about that on the live episode. If you're interested to hear our takes on that, check it out. We just did that one yesterday. And live episodes every Wednesday night, or almost every Wednesday night when we can do them, 8:30 Eastern. Hey, remember, you give this sucker a like. Subscribe if you like our content. We'll see you next time on The Big Mountain.